There's a very reliable report that the White House has characterized our lawsuit, that is the King-Lincoln lawsuit, as being against them, and that it's freaking out the White House.
Is that satisfying or what?
Well, on this point, if I could add, one of the transitions in my thinking about this has been to focus on Karl Rove and not confuse it with Bush. George W. Bush, it seems to me, is someone who is may well have relied upon Karl Rove as the guy that handles elections and is the guy you take his political advice, and not a person who's challenging his motives or his methods with any degree of intensity. And so to see Karl Rove as the guy who is, as Bush says, the architect, and to the extent that there's criminal conduct, is the guy that's conceiving of the criminal plan and implementing the criminal plan, I think is an important it's an important step in this, and not to impugn the president as being necessarily a knowing conspirator in this plan. And that's my current working hypothesis. And as we've talked about this, starting July 17th of 2008, we did not say it's the Bush-Rove, that Bush-Rove are the principal perpetrators. We said it is Karl Rove who is the principal perpetrator of this conspiracy.
Well, now, since he's no longer in the administration, could he still claim executive privilege and immunity against all these allegations?
Well, he can't claim any kind of immunity in civil litigation, and he can't be pardoned by the president for crimes under the Ohio statutes. And we have jurisdiction. There's no protection. He's vulnerable to discovery, exposure, and liability, and prosecution by our Attorney General.
Well, the other day we traveled to Cleveland, and you deposed Mr. Connell. What can you tell us about that event?
Well, we're still thinking about Mr. Connell. We had a lot of intelligence coming in about Mr. Connell. At one level, in terms of the roles that he's played as the head of the data processing or the IT function for the Bush campaigns in 2000 and 2004, and reportedly a similar role for the McCain campaign. And then his role, his intimate role as the instrument of many other aspects of Karl Rove's political strategies over the last 8 years. He appeared to be someone who could be a central figure in the corrupt practices that we think have been going on. But we were being told by, or from more than one source, that he took the oath seriously, and if asked, if compelled to ask, if compelled to respond, would speak truthfully. And further, that he had concerns about being forced in the position of being the fall guy for fraud that occurred in the 2004 election. So we pressed whatever the scenario, whichever scenario is true, we felt it was important to get his deposition. And we had the cooperation of the Attorney General's office and the Secretary of State and the court in proceeding, two courts, in moving forward to get his deposition. The fact that that Mr. Connell was in court, in federal court in Cleveland, from 2 o'clock to 5 o'clock on Friday before the election, probably was working with his counsel in regard to the deposition at some time over the weekend, and then was in deposition from noon to about 3:30 on the day before the election, would suggest that, at least from the standpoint of this critical point in time, he was not doing any mischief with the election process for the November 4 election, 2008. His testimony is, he revealed some facts that were important. One of the concerns that we have is that it's not just Mr. Connell with this dual role of being a principal figure in the Republican campaign, simultaneously serving in a governmental function in the critical state of Ohio in 2004 inside the Secretary of State's office, but also a company called Smarttech, which was hosting the server for the backup server for the Secretary of State's office in 2004 and 2006 in Chattanooga, Tennessee. And Mr. Connell indicated that while he first testified, he didn't recall that he had any influence in bringing Smarttech into the system, into the picture. In later testimony, when asked about companies with whom he had subcontracted work, he said, "Well, Smarttech might have come in as a bundled service under my company."
And was Triad involved or mentioned in that?
And he also mentioned that Triad had been a subcontract under his GovTech contract with the Secretary of State. And this was in regard to the changes in the database management of the voter registration database to comply with HAVA and the Help America Vote Act. And we knew already that in this election, Triad Corporation was doing the managing the voter registration database for more than 50 counties. I think it's 54 counties, and was actually hosting on their computers the registration database for 25 of Ohio's counties. So it's more than 50 out of 88, and 25 where they're actually doing it's on their computers. That's the primary site of that data. So the Triad is, according to our expert on cybersecurity, was intimately involved in electronic fraud in the Florida 2000 election in 4 counties where there was unexplained irregularities in the electronic voting machines that from a practical standpoint would have had much more influence on the outcome of that election than the hanging chads and so on. They were also involved in, according to our cybersecurity expert, intimately involved in the fraud and rigging of the 2004 election in Ohio by virtue of their role in programming tabulators in many counties in Ohio in that election. And something that greatly raised his concern is that they were changing out a hard drive, or one or more hard drives, in a tabulating computer. And the only explanation, well, the concern for a security expert is you don't change the hard drive to correct for something. Because the hard drive cannot be erased. I mean, it's difficult to erase it, but that is an investigator could detect malicious software, could detect manipulation by examination of the hard drive. So here's a company that it's not just our expert, but John Conyers' committee that did an excellent job in summarizing the evidence of the problems in Ohio in 2004, had identified Triad as a suspect company, had referred their suspicious behavior to the FBI for investigation. So given the fact that this company had that kind of a cloud over it, the fact that Connell is saying he brought them into this position of trust with respect to the 2008 election certainly is a matter of concern.
Do you think that the fact that Mr. Connell was involved in this proceeding had a dampening effect on his colleagues or underlings and their behavior during this election?
Well, again, we don't know. We don't know the inside. We don't know for sure. But we were getting this information. I think there were about 5 tips from a person high in the McCain campaign who obviously disapproved of the fraudulent conduct that he observed being in process. And he had indicated that the plan was, there was a plan to manipulate the presidential election result in the 2008 election. I'll just give you this one impression, that on Friday, Mr. Connell seemed very nervous about the prospect of being deposed. One of our clients was in the room looking at Mr. Connell when the judge began to issue his order that the deposition go forward, and indicated that Mr. Connell's face turned beet red. On Monday, he seemed very relaxed. And one possibility would be that whether because of the polling that showed that Obama's margin had just gotten very large, or because of concern about the operation being exposed, because keep this in mind, we had submitted into the court record every tip that had come from this McCain tipster. And so, in other words, we were reporting publicly and to the court that there was a plan to rig the election, designating who was in charge. That's Jeff Arnebeck, who is the president of Smarttech. And we think it may have had a chilling effect. But in any event, one possible interpretation of this change in demeanor of Mr. Connell over the weekend is that the plan to rig the presidential election vote had been abandoned, and which is what we had hoped would happen, because as we said when we got the order for the deposition, we said that anyone planning to switch votes might want to think of it as sort of switching the key on their jailhouse door, because they would be pursued, they would be caught, and they would be prosecuted.
There was some talk ahead of time that Mr. Connell had been subjected to threats from Rove or other parties. Can you tell us anything about his response to those inquiries?
I can't tell you anything about Mr. Connell's response to those inquiries regarding threats, because the court directed that any question on that subject and any answer on that subject would be sealed and only made available on order of the court. So that is protected and confidential information.
There was also a story that Mr. Magnan, who was on the staff of the Secretary of State, had been told by Mr. Connell that he couldn't be present because the private contractors were going to handle tabulation on the night of the election. Can you tell us anything about that?
Well, at the hearing before Judge Solomon Oliver on Friday in Cleveland, I had indicated that we understood that Mr. Connell was intimately involved in the Secretary of State's, Ohio Secretary of State's operation for the 2004 election, and was present at a meeting where Mr. Mangan, who had been an IT specialist for the Secretary of State's office for some 20 or 25 years, that he had been instructed the week preceding the 2004 election that he should leave the premises at 9 o'clock on election night. And he had been fully involved in the supervision of the elections, of some 40 elections in the state of Ohio. And this had never happened before, and the fact that this directive or this order or plan was coming from not from his civil service superior or the Secretary of State, but from an outside contractor or outside contractors, plural, seemed quite extraordinary to Mr. Mangan and to us. Mr. Connell indicated that he had no recollection of anything like that.
So what's the timeline in terms of the the next steps in this process, and will his testimony ever be taken from under seal?
His testimony, in the best of my judgment, will be available in the not far distant future. There's an assertion of trade secret protection. We agreed to that any revelation of trade secrets would be placed under seal. They are asserting that Mr. Connell's conversations with the Secretary of State in regard to negotiating the contract and in regard to various issues in the operation of the election are trade secrets. We've taken the position that that's not trade secret. It's normal. There's no special marketing concept or special computer concept that was being revealed that qualifies as a trade secret. This was discussed with the judge, and the judge, I think, ruled our way. But once the deposition is available, they've reserved the right to specifically make a claim of trade secret protection, and the judge has agreed to look at that. So before the full transcript, without the language regarding intimidation, that will be redacted. But other than that, my belief is the rest of the transcript will be available.
So what's the next steps? How do you see this whole process unfolding from here out?
And what we've been talking about is amending our case to assert a Corrupt Practices Act claim against Karl Rove as the principal perpetrator. We have a lot to bring to the table at this point. We have one of the top computer security experts in the world as an expert witness. We have a great deal of research and data that has, in regard to the corrupt practices. We have findings against some of the corrupt corporate interests in their role in corrupting the state Supreme Court elections. We have a very strong Ohio RICO statute that it's not just modeled on the federal statute, that was the innovation, a statute to better empower our federal government to fight organized crime. A number of states following that model drafted state RICO statutes. Ohio's RICO statute is regarded as one of the strongest in the country. And it has provisions which are very favorable for the prosecution or for plaintiffs. The concept of RICO is that private people can bring the action. If certain provisions of the act are being invoked, the Attorney General of the state has the option of analyzing the case and taking control of the case. If the Attorney General chooses not to take control of the case, the private party may proceed. Now, in our underlying litigation, the King-Lincoln case, we entered into a settlement discussion with the Secretary of State and her legal representative, and part of the settlement concept was that the state of Ohio and the Attorney General's office would undertake a criminal investigation of the fraudulent conduct against our elections. So we would prefer, because of the magnitude of this situation, that the public authorities be the ones to conduct the investigation and prosecute the violations of law. So we view ourselves as sort of a transition mechanism, or providing assistance to what we would like the public authorities to do. The new Attorney General of the state of Ohio, the new Attorney General of the United States government, should place a high priority on understanding the fraudulent conduct that's been directed at the rule of law, undermining the rule of law in the United States. And that this is not a partisan thing or a vindictive thing. This is something that, if you analogize it to what happened in South Africa, where there were terrible crimes committed, when the new regime came in, they did not seek to penalize. They said, we have to understand what happened, and if we can get the truth, we can have a reconciliation. We'll not punish. And this what we're talking about is something on such a much larger scale than Watergate. And the penalty and the consequence to people who were involved in this conspiratorial activity against the rule of law, against the very foundations of this country, the consequences of having it known is a pretty substantial penalty in itself. So we would hope that the public authorities will get into this, will take leadership and control, and we will assist by passing on what we know, and perhaps having provided a legal vehicle in terms of the Ohio statute and an Ohio proceeding in which they could carry it forward. But we don't know that until these folks are elected. But in office. But keep in mind that even in the Bush administration, Gonzales was asked to leave office by the public interest community. He did leave office, and now Attorney General Mukasey, under his leadership, there is a special prosecutor investigating the White House improper influence in the firing of the U.S. attorneys, 9 U.S. attorneys. So there was an internal investigation, now appointment of a special prosecutor, and this goes right to Karl Rove. So I think there is evidence that Mukasey feels an obligation to carry out his commitment to try to restore the professionalism and the tradition of independence that has characterized the Justice Department over its history prior to the current administration.
People are going to be saying, I can imagine, that the election of Obama and the transformation of America into a new phase makes all of this kind of moot, and
well,
just being a little bit bulldogish about this.
At some level, let's say it supersedes, the election supersedes the litigation and congressional investigations, in the sense that we terminated, in this election, the plan to tamper with the presidential vote seems to have been terminated. It didn't come into play. It's not to say that there was not manipulation of other elections and voter suppression that was targeting other elections, Senate races and U.S. House races and even state House races. There was voter suppression activity, shifting people into provisional voting status so that their votes wouldn't count, interfering with their ability to vote, targeting African Americans and targeting college students, just as occurred in 2004 and 2006. So there's still something to investigate and still something to hold people accountable. But in terms of the imminent threat of having a third presidential election stolen, the strategy of having an overwhelming vote was a good strategy, and in a way superseded anything we had to do. And now, as to whether there's more work to be done, one possibility would be that the new Attorney General of Ohio and the new Attorney General of the United States would say, this is a big conspiracy. This was a big conspiracy. The United States Chamber of Commerce, the tobacco industry, all kinds of corporate interests, the financial people, corrupt financial interests, all kinds of people were involved in this. And it's such a large political crime that implicates so many people, including people who spent a lot of money supporting our election in order to try to forestall any kind of investigation, that maybe the better thing to do is to not prosecute, not conduct a criminal investigation as a matter of discretion. Let's go forward, let's be positive, let's try to bring everyone together and restore the rule of law, let bygones be bygones. That's a possibility. As to the civil rights clients or the civil rights community or the public interest community, we believe that there's an opportunity here to proceed with private litigation and try to build a war chest for fair elections in the future, for honest elections in the future. And what we would like to do is get the business folks who put up money by the hundreds of millions of dollars to corrupt our political process come forward with a large amount of money that could be the basis on which we have an improved election process, a kind of public financing or pro bono contribution from these corrupt business interests to make up for what they did, that will allow us to have elections where the candidates don't have to go out and become potentially influenced by large corporate, large donations and private, interested donations. One of the purposes for proceeding with this litigation is to discover who put up that money that has corrupted, attacked judicial independence in the United States and the states, at the same time that you were electing through and using front groups to make attacks on John McCain in the South Carolina primary election of 2000, and then subsequently it could the swift boat attack on Kerry and things of this kind later on. So, and another point about this aspect of the litigation, even the people who advocate unlimited spending in politics, the companion to their advocacy for that concept is that there would be full disclosure. No one is publicly advocating the position that people should be able to spend a great deal of money influencing the political process without a system of disclosure, so that the public, as they're reacting to the advertising, has a sense for whether or not there's some corrupt interest behind it, some angle that's being played, which then affects their ability to evaluate the truthfulness and be persuaded by that advertising. So even at the discovery phase, not getting to the ultimate decision of liability, but just the discovery phase, by getting the subpoena to the Chamber of Commerce, or the discovery demand enforced by the court, we expect to get the names of every corporation that put up, by date, by amount, by name of corporation, every dollar that was spent to engage in character assassination and in some cases, and just name ID advertising for the Republican candidates for state Supreme Courts and Attorney General's office, elected Attorney Generals in many of the states in this country.
Is that a separate lawsuit?
No, what we envision is that it's the same conspiracy, that the deal that was being presented to the corrupt business interests by Karl Rove in 2000 was elect us president, and we have a plan to undermine the rule of law. Basically, you can have open season under our administration, open season on the American public. There will be no regulation, diminished regulation, diminished legal liability, and any system of creating open season on the American Republic requires not only that you defang the federal government, you have to defang the state system. So this attack on judicial independence in the states was part and parcel of the same strategy.
As things stand now, is there anything more that you feel that you want to say about this situation, or in general about the current political climate?
Well, what I would say is that the election of a President Obama is a wonderful opportunity for us and for the world. And while we look at the crises that we're facing and think, can he do the job? At some level, the job is really very simple, because the job is to restore the rule of law and the system of checks and balances on which this country was founded. I mean, that is what distinguishes us in the history of civilization, that we had a written constitution with checks and balances, and we were a government of laws, not men. So the fact that Obama is a lawyer, a conscientious lawyer, a good lawyer, and a very intelligent man, much of the reform or change that he has to, all he has to do is restore the order we previously had. And I'll refer you in regard to foreign policy. Brent Scowcroft, who was the National Security Advisor to George Herbert Walker Bush, made the comment that he didn't recognize what had happened to Dick Cheney. He said, I worked with Dick Cheney. And he understood the concept of avoiding hegemony in any one country, and this was a tradition within Republican and Democratic administrations. And now he's off on a plan to establish the United States as the dominant power in the world. I mean, it's contrary to the whole philosophy of our foreign policy in all prior administrations. So what we really need to do is restore ourselves to our former status as a nation of laws, a nation that recognizes the importance of checks and balances to prevent abuse of power. And I think the American public probably picked the right man to do that job.